Hello, the aim of this video is to provide an update for students who are studying commercial law during the academic year 2019-20 and try and give you an update on where we are with a number of things and the latest developments in this area that you should be aware of in, say, courseworks or exams. My full commercial law course is available on my website or via Gumroad, and I'll make sure to put links in the description of this video below. But let's get started with this video, and to be honest, the main subject that is affecting commercial law at the moment is the issue of Brexit. At the time of recording, the only thing that we can say with any certainty is that while negotiations are ongoing, the UK still remains a part of the European Union, and that doesn't really look set to change anytime soon, but it certainly could well do, whether that's October the 31st or if there is an extension sometime after that. Anyway, at the moment, while the UK is a member of the EU, the exact nature of any Brexit agreement is still yet to be decided, and it's still perfectly possible that the UK could crash out without a deal at all. And so there's a number of things that we need to consider within a commercial context. Now, whatever happens, if there is some sort of Brexit deal, the UK is likely to become a third party in relation to the European Union. And that has a significant number of consequences. In the first instance, there's probably going to be a requirement of import or export licenses for various businesses and commercial companies that are doing business with the European Union. The UK is going to set up its own economic operator registration identification numbers, so each business will need their own one of those, and the businesses are currently in the process of doing that at the moment. There's also going to be the application of customs, excise and VAT procedures, so probably going to be a significant number of delays for companies who are trading with the EU. And it's also possible that there could be tariffs, although it is worth saying that at the moment the UK is planning on imposing 0% tariffs on goods that are being imported from the EU, or certainly the vast majority of goods that are being imported from the EU. So there shouldn't really be any change in that regard, but that could also change in the future as well, depending on government policy. One of the other things that's going to change is the marking. You may see it, the marking on the left-hand side is fairly familiar to you if you have, say, electronic goods such as a mobile phone or games console or anything like that. It's basically just the conformity marking for the European Union. And on the right-hand side, this is going to obviously change after Brexit, and so we have the UK conformity assessed marking, which will be on those goods instead once the UK does leave the European Union. Other aspects of conformity are really important as well. At the moment, we have the idea of mutual recognition, where if a good can be sold in one of the member states of the European Union, then it can be seen as something that can be sold in any of the other member states. Now, obviously, when the UK is no longer a member state anymore, that idea of mutual recognition will go away, and so the UK goods will have to instead comply with a conformity assessment body, which are bodies set up by the European Union to assess goods and whether they conform with European standards. There's also going to be geographical indication that would need to be put on. This matches up with the World Trade Organization requirements at the moment, so it won't be too different for the UK after it does leave the EU, but it will be different, and so the UK will have its own PDO, Protected Geographical Indication as well, PGI, and Traditional Specialty Guaranteed Markings, TSG. The other aspect of the WTO that could well apply after Brexit is the remedies that are available to the UK as well. And again, it shouldn't be too different because the remedies that the European Union uses are based on that World Trade Organization standard, and so the remedies that will be available to the UK will be relatively familiar. Firstly, we have anti-dumping, which allows the UK to place duties on goods that are being deliberately exported to the UK at a drastically cut rate price, often below the actual sale of production. So if that does happen, then the UK will be able to impose duties. In a similar sort of fashion, we also have the UK being able to apply duties to goods that have received financial assistance from the government, and that is something that is particularly in the news at the moment in a commercial context in relation to Airbus exports to the United States, And the United States complained to the World Trade Organization about this in relation to the subsidies that Airbus receives from the European Union, in fact, and so the US is now going to be able to impose tariffs on the import of aeroplanes from the European Union and from Airbus in particular. There's also safeguards, which are basically just short-term measures against sudden import surges, and so this is something that can be used by the governments as a sort of protective measure. So the UK will still have this once it does leave the European Union. Well, that's all from me on this particular subject. As I said, make sure that you do check out the full commercial course if you are studying that this year. Otherwise, I hope that this little update has been helpful and gives you some idea about what could well be happening in a commercial context after the UK leaves the European Union. Thanks very much for listening. Bye!